started. I don't know if you are aware of that, but Codex, the Center for Legal Informatics, our tagline, our motto is legal empowerment through information technology. And when we tell that to anyone who we introduce Codex to, the second sentence is usually, and our mission is to empower all stakeholders in the legal system, and not just the legal profession. We realize there's a lot of interest in in technology, helping the legal profession kind of find its way through the big kind of disruption that it's facing right now. But really, our mission is to give non-lawyers and all stakeholders in the legal system the tools they need to get access to the law. And so we've been for some time, we're actually at the point in our class that we're actually wrapping up Module 2, which is concerned with legal infrastructure, and we're about to get to computational law, which is our Module 3, and Mike's going to start talking about that next week. But we see computational law really is the central and most exciting goal for Codex. That's where we see the revolution come. And we think some of the most interesting applications of computational law are really in the access to justice space and empowering non-lawyers with technologies. So for some time we were thinking about, basically, what's the best way to kind of disperse this technology and get it into the hands of people. And then at some point we realized that, hey, there's a thriving community out there that's generally known as the access to justice community that's been thinking about the use of technology to empower individuals, and particularly indigent individuals, for quite some time. And we're very fortunate to have two key figures from the access to justice world here with us today. So Bonnie Huff is a managing attorney with the California Administrative Office of the Courts, AOC, Center for Families, Children, and the Courts. She also serves as the committee counsel to the Judicial Council's Task Force on Self-Represented Litigants, and is also staff to the Elkins Family Law Task Force. Bonnie's been a very powerful advocate in California, particularly for Californians who representing themselves in court because they cannot afford a lawyer. She has helped launch the Family Law Facilitator Program, which is the backbone of the state's self-help court program. And this has been a very successful program that spawned a number of other self-help centers that provide assistance to self-represented litigants in areas such as landlord-tenant, consumer, and other issues. She has also spearheaded the development of a self-help website which has over 900 pages of legal information and links to other legal assistance programs. So Bonnie received her JD from Hastings College of Law, and she holds an MPA from San Francisco State University and is a fellow at Harvard Law School's Bellows-Sachs project. Also with us today is Catherine Alteneder. She's also has a background in legal services, the courts and private practice. She, after law school, actually clerked for a judge and then worked for the Alaska Legal Services Corporation. She then joined the Alaska court system to develop a statewide family law self-help center, which resulted in the nation's first virtual self-help center. And she's also worked since 2008 in private practice, where she established a successful unbundled practice supporting self-represented litigants in Alaska, and has also helped create the unbundled law section of the state bar. So Catherine's also a member of the represented litigation network, and is a published author and speaks at several conferences in the A2J field. So I don't know who's going to go first, but I'll just turn it over to our guest speaker. So.
Thank you. Thank you. Thank you. So it's a joy to me to be able to work with Catherine. She is now actually the director of our National Self-Represented Litigation Network, and I am one of her board members as a trying to support her amazing work. And the National Self-Represented Litigation Network is a fairly loose group of people from throughout the country who are really working to promote knowledge and expand services for people without attorneys. And there are a lot of them, so I'm going to talk a little bit about that and start with the California experience. But is there anything you'd like to? Okay, all right, So I just wanted to give you a little bit of context because at least for me when I think about virtual services, it's helpful to understand what's out there and what's going on and why somebody who works for the court system is engaged and interested in this issue. So just a little bit of context, 38 million people here in California, 40% of them at least speak a language other than English at home. Which poses all kinds of interesting challenges in terms of education support, that kind of thing. We are one of the largest court systems in the world. Los Angeles itself is probably the largest. It has 660 judges, just to give you some context in terms of being a really, really big system. But it's a very diverse state, which you don't always know when you live here, right? Until you're actually, it's 58 counties. From Alpine, which is up there, to Los Angeles. And then we have someplace like San Bernardino, which is larger than most states, certainly in the eastern part of the U.S. So it can take 8 hours if you want to send somebody across that county, and which, as when courthouses close, it makes things really, really challenging. So it's a diverse state. We've been able to pilot a lot of models as a result, because we can deal with these tiny urban areas, these tiny rural areas with 1,200, 2,000, whatever people, and we have some really large areas as well. So why do we care about self-help? Why do we care about people coming to court? So in California, over 70% of the people who come to court in divorce and family law cases start their case, at least without a lawyer. And interestingly enough, my hypothesis was people would start without a lawyer and then realize, oh, this is really complicated and tough, and they'd hire a lawyer. No, most of them run out of money. And so way more people are finishing 80%. This is 10-year-old data. This is 10-year-old data. That's the best data we have at this point. What the courts report, those that are continuing to do this, is that it's in some jurisdictions as high as 90%. Again, but let me be really clear when I say this. They are appearing without an attorney on the paperwork and in a court hearing. That doesn't mean that they're not getting legal help or attorney assistance, either through forms completion programs, self-help centers, unbundled attorneys, or whatever. But when the judge sees a courtroom full of people who really have serious legal problems and there are no lawyers, it is an issue that they want to take care of, right? They want to deal with this. 90% of domestic violence cases where somebody needs a restraining order have no attorney. 90% of the tenants in eviction cases, generally speaking, don't have any attorneys. And one of the really interesting things I don't think people pick up on is that 30% of the landlords don't have lawyers. I've been doing case file review for a county, and I'm just shocked, right, at how many people don't have lawyers. Again, many of them are getting help with document preparation, but it's certainly a whole different kind of thing. The other thing that this doesn't pick up on that I would like you to consider, because we haven't figured out how to deal with it and I need some smart people thinking about this, is the whole range of consumer cases where people are being sued for bad debts, and there's an attorney in the case because the collection agency has lawyers, but all the people on the other side are not showing up, right? They're defaulting, and we don't exactly know why. We know a little bit from the self-help work that we do that they owe the money. Why would they fight it? We know that it costs to file a response. It can cost $300 to file a response, and a lot of people are like, if I had the $300, I could pay the debt. A lot of people are sued for things because their name, I have a weird name, but it turns out there are a lot of people out there named Bonnie Huff, and it would not be unlikely that I might be sued for their debts and kind of go, I've never done business in the state of Texas, whatever. And so not even think to file a response because it would be so obvious that I had no connection with the case. We just don't know. We don't know. And so there is that, at least when I talk to judges, they say well over 90% of those cases are defaulting. Nobody's showing up on the other side. And I think that has real implications for access to justice as well. But one of the interesting things, certainly in California, and it turns out we're not that different from the rest of the country, is a lot of people, when they have a legal problem, go to court as their first place to go. They don't go to lawyers. They don't go to legal aid. Interesting, so they're here and they're in the clerk's office, and the clerk is trying to go, how do we, what do we do? How do we get you to some guidance? What we have found is we've started self-help programs in California in about 1997. And I'll talk a little bit about the history, but what we're seeing is that this is a trend that's growing throughout the country. There was one, Arizona in fact, was the first self-help center per se in the country. We had a lot of legal aids that were operating little programs, that kind of thing, but Arizona was the first place that court said, we're going to start providing assistance in this area. But you can see that it's grown dramatically. This is just 2013 data. I actually know there are 2 programs in Nevada, but they didn't respond to the survey data. And we've just picked up a couple of others at a conference we were at last week. But generally speaking, it is absolutely a trend. We have now, what, 450? Yeah, 450 programs we've identified.
And it might be worth noting that the thing that opened the door for courts to do self-help was an article by somebody named John Grisham, who also is on our board of the network, that distinguished legal information from legal advice. So the courts historically were bound, they have to be neutral and impartial. They can't give advice. And so you go to the clerk's office and say, how do I get a divorce? Go see a lawyer. Is this the right form to file? Go see a lawyer, because it was seen as that you were going to be giving advice. This article that distinguished information from advice really opened the doors and has allowed this to develop, where courts feel comfortable now giving legal information, which is generally the easy way to define it is, can I get a divorce? Yes, you can. Should I get a divorce? Well, that's advice. Go see a lawyer. So it's largely a semantic thing. The way we have constructed legal information for websites and so on and so forth, once we put it up there, that's legal information. We have sanitized it, and it is not being deployed in a way that's customized to your situation. So that sort of runs through all of this, I think, in terms of opening up the field.
No, I think that's really important. In fact, in California, we used to have 900 pages. We now have 4,000 pages of legal information on our self-help website, and the entire website's been translated into Spanish. So, and it's very step-by-step. This is how you get your divorce. This is how you do this thing or that thing, plus additional advice, resources, links. But again, when I'm talking to clerks, I say, there's a lot of information there that you can be providing, and it's good, credible, free information. Yes?
So, what I understand, you're saying that basically that people are going to court to look for the information, not because they're thinking they will give them the solution, because they simply don't know that what they're looking for.
I think there's some of that, but I think honestly more people go and say, I need to get a divorce, I know I need to go to court. I think a lot of people really feel like they can't afford an attorney, and so they just need to know what the steps are. And in the past, the clerks would just go, well, I don't, they might have a form packet. I mean, that's one of the great things in California, but it's
because my question is whether it's the problem of naming, of actually knowing what your problem is, or for example in insurance or accident, those are usually problems, and people know they need a divorce, but it's not a problem of naming rather than how you do the procedure, and that is different.
Right.
Can you differentiate more on those two sides?
Yeah, I don't know. I mean, I'll take a stab, and Catherine, I'm sure, has some ideas. I think there's a little of both. I think there's a huge amount where people say, I have heard that this, okay, let's take domestic violence restraining orders. I think I should get a restraining order. If you went to a domestic violence advocate, they might say, you really need to think about this, because a restraining order is really a piece of paper, you know, that the judge has signed saying stay away. And with some batterers, that will make it worse. That will be, you know, the red flag in front of the bull saying, I'm going to go. Do you have, what's your plan? You know, do you have a place you're going to live? Have you figured out how you're going to support yourself? They really want to talk with people and think things through. One would hope that in many divorce situations that somebody would help somebody sort of say, how are you going to do this? But people will go in and say, I want a restraining order. And there's a nomenclature, there's a naming issue. So I will say, I get calls from people that say, I have a family law problem. My brother just got arrested for this crime, and he's a member of my family, so it's a family law problem, so they're calling me. And I have to say, I have no clue, right? So there's a little of that, and we found on our self-help website, we've been very conscious of trying to write in plain language, and we'll talk a little bit about that, but we try to write in terms that we hope people will understand. So we talked, for example, about how to clean up your criminal record. And what we found was one of the most common search terms was for expungement. Expungement means cleaning up your criminal record. But people were being told, I assume, that they needed to expunge their records, and they weren't finding that. So we need to be very mindful of the language and how people process and think about things. Yeah.
Just pertaining to that exact issue, I think it's really interesting talking about these issues within the larger purview of legal technology. And that reminded me of, there's a legal access project at Stanford Law School called Law Gives. And they had the exact same issue of, we want to field these legal questions from people, but how do you categorize it? How do you know, right? And so what they use is natural language processing, which will sort of like machine read the words in whatever query, and then, you know, batch it accordingly, and then send it off to the right lawyers who have self-identified as, I specialize in immigration or family law, and like, so all that is automated. Yeah, so like the possibilities of decreasing man hours by just automating so many of these little tasks, this is incredible. Yeah.
Absolutely, absolutely, and continuing to watch it develop. All right. Did you have any thoughts on this?
Well, just for the self-help centers, for just some definitional things, I guess, to keep in mind, they are for civil law, right? No criminal, and that's an important distinction. And the majority of cases that, you know, where we see those statistics of self-represented in California, you know, those hold true nationally. But they're family law, landlord-tenant, small claims. That's where, you know, it's the people's law where they congregate. And so, to the extent when they come in, do I know what my question is? I'm breaking up, or somebody says I owe child support. I mean, they come in with that, and then have to be sorted from there. So, yeah, I mean, I think your point is well taken of how can we sort them more efficiently. But they also, you know, the Greek chorus is pretty loud in people's lives, because it turns out a lot of people are having these problems, so they get a lot of advice from their friends who have been through this, and, you know, I know I need this form. You know, they come in ready for that form. They might be wrong about that, but so we do have to fight the Greek chorus often.
Can I just say, there is a sort of dirty little secret, though, in California, and that is at least 40% of the people, and this again is old data, and I think has only gotten, in my opinion, this is worse, but at least 40% of the misdemeanor cases, people don't have lawyers. Because many public defenders take the position that they will not establish an attorney-client relationship until after the plea. And so there are vast numbers of people who are going in pleading without any kind of legal advice at all. And it doesn't make me happy, right? Because we have civil getting and everybody has the right to an attorney, all that kind of stuff. But people go in, and I really think that we should at least again be providing some level of information so people know what their rights are. In fact, in some courtrooms, there's not even a prosecutor. I mean, in many courtrooms, there's a prosecutor, no defense attorney, and people make that decision about how to plead. But in some situations, the judge is having to be both the prosecutor and the, well, not defense attorney, but saying, here's the situation, how do you plead? And the person says, I don't know what to do, and the judge has to say, I can't provide any, they certainly can't provide legal advice about what it is, and there's really no place for somebody to go to get information at that point, and the consequences of a criminal plea are pretty significant. But, yeah.
I was wondering if you had more information on the article that you mentioned that distinguishes legal advice from legal information.
Yeah, we can, I suspect we get a lot of questions of materials, and so we can send those afterwards to Dr. Vogl, and or you can Google while we're going. Greacen, Greacen.
And it's the difference between legal information and legal advice. And we cite to it all over the place. It's a really helpful distinction.
More questions?
Yeah.
Okay,
sorry.
In the California misdemeanor case you just mentioned,
right.
Can the defendant, I guess, actually request a public defender for the plea? I mean, I know one's not provided automatically, but can they request one?
I mean, I think it may depend on the county. At least the public defender that I talked to said no. But, yeah.
A question, you mentioned $300 for even filing a response. A lot of people don't want legal advice because it's too expensive.
Right.
What do you think would happen if the legal advice was for free for these people? Do you think they will use it, or they still won't use it?
Oh, I think that we have huge numbers of people coming in. We have 1.2 million people that come for self-help centers in California now, 1.2 million. So I think people do want information, and whether or not, then they can make a decision about how they want to act on it. And it may be in their best interest not to file a response in a case, or they may make that choice. But I think that there's a huge need and demand for at least some level of information and assistance. Yeah.
But also for pleading at the court, 70%.
Oh yeah, well again, I think, it varies. I have to say in California, we, for example, in family law, have developed a system that makes it you can actually do a default divorce in California with an agreement from the other person, because the filing fee is more like $400, and we want agreements, we want to encourage people to do it. So we have this very odd kind of system, frankly, that I helped develop. But, as a way to encourage people to at least participate, even if they're not going to officially make an appearance. So there are a lot of ways, but as I say, I can totally imagine in a consumer case, if I owed money and I thought, I don't have any defense, I bought the refrigerator, I didn't make the payments, I don't have any way to make the payments, I'll just default, and good luck if they can track me down. So I think it will really depend on case type. Or in a landlord-tenant case, I'm going to be evicted. The reason I'm being evicted is I didn't pay my rent. Do I want to pay a $400 filing fee to the court to fight it, or do I want to save that $400 and have some kind of deposit for the next place? That would be a rational decision, in my opinion, to default. So.
But just to follow up on that, and this is where that question of where the legal advice comes in, if you have a housing voucher and you are evicted, you will lose your housing voucher. There might be a way to negotiate your exit from the housing without getting an eviction on your record. Or there was a county here, right, that was just not, the landlords weren't renting to anybody that had an eviction on their record. So offering, we have projects where we put volunteer lawyers in that work on settlements and trying to help people, move on to the next step in their life without the negative ramifications. But they don't understand the downstream consequences of their choices. And so part of this big challenge, and we're going to talk a lot about, how we figure out how to, well, the question is, can you build an algorithm that can think like this and anticipate it? Is how much information is too much? When do we deploy it? When does it matter? How do we find out enough information from the litigant? So we're going to kind of dive in deep on that stuff, because that is the heart of the matter for us. Oops,
okay, I'm sorry, yes.
Just real quick. For the people who are representing themselves and find themselves without the legal expertise or legal knowledge to do a good job, do you find the issue is more that these people aren't aware of the resources that are available, or that there are insufficient resources that are available to them, but they're actually looking?
I think my sense is mostly that there are insufficient resources. I mean, do you have a sense of that, Catherine?
Yeah, well, and also then it depends on the capacity of the litigant, and we're going to talk some about literacy. I mean, and there's more than literacy. If there are mental health challenges, substance abuse issues, just sort of whatever is going on in their life at that time. So what they do with the information once they get it, there are a million variables that impact that processing.
Yeah, and part of it's, you know, going to depend if you show up and you think the other person's representing themselves, and so, okay, I'm going to go into court, and then that person shows up with an attorney that day, and you're going, I wasn't anticipating having to, I thought, you know, we would have this discussion with the judge. So it's, I think that also happens, where all of a sudden it's just way more complicated than they thought. Yeah, it's hard. I don't know that we have a lot of information, but it's a little hard to know. So I just want to go back and say, okay, so we have these 38 million people, and a whole lot of them, right, with legal problems. And so we have the self-help website. Our hope is it's a great place for people to get information, www.courts.ca.gov, in case you want to check. But it's a lot of information. That's wonderful. We're trying to do, we have forms and instructions on how to complete forms. That's a huge issue in a lot of states. Not so much a problem in California, although not everybody, of course, can understand forms, and it gets, you know, that can be a little bit intimidating for people. But it helps lay out the critical elements in a legal case. So you're not fighting over, did the person know that they had to say they lived in the state of California, right? You don't want to send, you know, in my opinion, you don't want to bounce a pleading because they've missed some really basic thing that is just dumb, right? That they didn't know that. We're doing a lot of court staff and judicial education. We've actually done a lot of research and written a book for judges on how to handle cases for people without attorneys, how to communicate, what are the ethical issues, how do you manage a courtroom in those situations. Trying to encourage the bar to provide pro bono, free, or limited scope assistance, and trying to increase funding for legal aid, because I do think a lot of it is that people just don't have access. But our primary thing in California, the thing that our state court system decided is that the best way that we can assist people in California is with self-help centers. And when we talk about self-help centers in California, we are talking about being staffed and supervised by an attorney, which is very different than the model in some other states. And it has to, and an experienced attorney. Statutorily, it's 5 years, and you know, kind of obviously sometimes there will be some exceptions to that. But and what they're doing in self-help, and what we're trying to do is really provide assistance, what forms to use, what the procedure is, how things are going to go. We actually don't, in self-help in California, necessarily say that we're not providing legal advice. We try to sort of skirt that issue to a certain degree. What we're trying to do is provide neutral, effective assistance. But when I volunteer in a self-help center, what I think is, if I'm talking to you, would I say the same thing if the other side were there? If your ex was sitting right beside you, would I be providing the same information? So you can provide very detailed information, but you're probably not saying things like, well, if you really want to get rid of the guy, this is, you know, what you do. You're saying, here are your options in terms of custody and visitation. This is how law works in the state of California. And one of the key things with the court that is really, really critical is that we are neutral. We provide assistance to anyone who walks through the door. And any program that's operated by the court, we don't income screen. We don't income screen. We might tell you, you know what, you've got a house here, you've got a pension, you've got things that are frankly more complicated than we're set up to do. And there's money at stake, and it probably makes sense for you to hire a lawyer. We're happy to provide you information, we're happy to get you started, but we don't have an income screen. And frankly, we can serve about twice as many people because we don't have to go through the whole process of trying to establish their eligibility for service. Yeah.
I was just gonna wonder, I was wondering if you ever got in like conflicts of interest problems, like if you're not offering, I guess, an official legal advice really doesn't apply as much, but like you still try to adhere to conflict of interest, like
No.
two parties in divorce?
No, we're very conscious not to. You can have two people can come in for the same workshop, or they can come in at different times. And what we say is, basically there's no confidentiality. We say, you know, anything you say here is not confidential. On the other hand, What we do go by are, and we have guidelines and rules on this. If it, as a court employee or judicial officer, we go by those guidelines, there's a requirement not to make public comment about a case. So the idea is that we're not going out and saying, hey, Catherine, boy, I talked to this person today, let me tell you. Oh my God. You're keeping that confidential and private. But if the theory is if Catherine were subpoenaed and asked to say something about the case, she would not be in a position where she could say there was privilege that applied. What she might say is, you know what, I would love to share that with you, but I see 30 people a day, and my recollection of this person is kind of limited. Take a look at the pleadings, that's the best I can do. And we are very careful not to keep files, not to keep records, but they can assist anybody that comes in the door. But on a practical level, I will also say, if you're in a small county, or if you think that there is a potential for conflict, like you've seen the person before, they were your client, they're your next door neighbor, whatever, that in a larger county you can just say, I'd really like you to talk to my colleague here. In a smaller county you might say, work out something where they can see somebody in the next county, or get assistance in another way if it's a real conflict. Yeah.
So the beauty of the internet is here, I'm playing around with the
Okay,
website,
yes.
and a lot of information, and really looks very interesting, lots of forms. I haven't found one yet where you can actually submit a form via the site. Is that something you do or you don't do, or you're never going to do, or you might do in the future?
We don't have any e-filing capacity in California yet. So that's what I'm hopeful that we will shortly.
When you say we, who are you referring to?
The California
Anybody?
courts. Nobody.
No court.
No court. No court. The only thing, we've got some complex civil litigation, asbestos litigation in San Francisco. You can e-file. I mean, it's gradually growing, but as a general rule, there's very limited e-filing. We have an e-filing project with landlord-tenant cases in Sacramento and small claims, but it's super limited. And as we get them up, we'll link to that county, but it will be county by county, unfortunately.
So you'll fill out a form and push submit, and it will.
Yeah, it's very sad, but true, yes.
And that's nationally, this is.
I understand it's the case, I'm just wondering whether it's on the roadmap.
Oh, yeah.
And
Oh, yeah,
Rachel
we
wants to do it,
hoped
right?
it would have been this, last year, but no, yes.
What's the limit there? Is it courts not wanting it? Is it courts not being able to connect with someone who can provide the infrastructure at a cost that makes sense for courts?
Yeah, it's more the cost issue. Right now we're operating last time I checked, we're operating 258 different case management systems in California. And so for a vendor to come in and say, I'm going to connect with all of you is kind of impossible. We had been developing one case management system for the courts, and then that would have been, and we were establishing structures and whatever. That crashed, but it didn't crash. The funding was ultimately pulled because the implementation costs were high, and there were a lot of political issues that got raised. But I think there was frankly a lot of courts deferred action because we all thought this was going to be coming up any day now, and that had a whole e-filing component associated with it.
So if someone was able to provide a better case management system that could link to form submission online, do you feel like there's barriers within the court if that was provided at a low cost? Like, are there judges who think, I don't want that to be the
Yeah,
status
but
quo?
that's not, but yes, there are judges who think that, but I don't think that's, yeah, I think the court administrators will encourage them to get over it because there are huge benefits to the court to have an e-filing system because keeping track of paper is really, really challenging. And those courts that have, what's happening now is we have a lot of courts that image the documents when they come in, and then judges can get access to them at any time, and that's, judges who get used to that totally dig it, but, there's a certain amount of initial resistance from judges who tend to be of a different generation than
I'm going to follow up this one step further. So
Sure.
supposing that an organization outside of the courts were to produce a nice form submission system and were to integrate it with one or more case management systems, what would be the steps that would need to be taken in order for the courts to approve that or to accept those submissions from that organization? Are there any hurdles there?
No, No, I think what, I mean, and this is, I mean, we're really poised to do this in a lot of courts. I mean, Orange County is moving, if you file a civil case, and I should, you know, Orange County is taking their civil cases through e-filing and wants to do more. We have rules of court that were recently adopted. Phil Malone helped in terms of, we have access principles. There are certain requirements in terms of just the programming that's needed to, you know, convey this piece of data into this kind of system.
I'm more concerned with whether there's any legal or approval hurdles that would make that just insuperably difficult for people, even though they had the full implementation technically.
Not that I'm aware of. And we've done some cool things in California, like you don't have, in some jurisdictions, it's really a problem because they require notarization of documents and a wet copy signature. That makes things difficult. What we did rationally, and over 10 years ago, was say, you know, they can just do an electronic signature. We don't check, when somebody comes to the courthouse, we don't say provide your ID and prove that you're actually the person who's filing this paper. You know, if you want to file in the court and pay your $400, we'll take your $400. If there's a problem, we'll deal with it.
One last question.
Sure.
If one were to try to do this, what would be the best court systems to, which best would be the best 2 or 3 courts to work with?
That's a good question. Well, LA and Orange are poised, are buying, I think are going to buy the same case management system, and they're probably ready to go. Here, Santa Clara is probably the most advanced. I don't know. San Mateo's really worked on e-filing in the past. Yeah. I mean, it has more utility for a big court, frankly, than a small court. And that's the other thing is, it's not. It's also that the court has to enter all this information in, right? You know, it's. I mean, ultimately, the e-filing will drop a lot of things in, but anytime you set up a new system where you have to put in all the case information, it's a huge challenge, and so it's a big commitment. They're going to go with one system that they hope will last for a significant amount of time.
Can you just elaborate a little bit on the sort of the failure of creating this sort of unified case management system, and what were some of the reasons why this ultimately didn't get off the ground?
There are a lot of reasons. It was a huge project, right? We're dealing with 58 courts. There were, in terms of the design, there were 6 lead courts that sent representatives to sessions with Deloitte. Deloitte was our lead vendor. And then there were some subject matter experts. I was a subject matter expert in family law. There are real challenges when you design with a lot of people. You know, when we'd have a judge's focus group and they go, this is blah, 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 this is what I want, and then they bring them back, and you know, sometimes the judges couldn't make it or whatever, and they go, yeah, we said that, but maybe not, or we didn't, you know, now that we see it, we don't like it, and then they change it, and then another group of judges would come in and they say, you know, not so much. So there was a certain amount of that. I think those of us who were down there every week, at least they were getting sort of consistent information, but I think that's a challenge. Everybody likes to see things displayed differently, whatever. The other reality is, on a political level, when judges realized that all this information would be available about how they were ruling on cases, how long cases took, all that kind of stuff, they became, I think, understandably concerned about elections. You know, and how was this information going to be used? And would somebody be able to say, you know, Judge Jones only rules for women, or, you know, all kinds of, I mean, you take data and you can spin data any way you want. I think there was a legitimate concern about a lot of access to that kind of data. There were a whole lot of factors. It was about to be implemented right when the economy tanked. And there was just this huge, you know, lack in the courts. It also was about to be implemented right when we lost our Chief Justice, who'd been there for 17 years, and kind of would have probably pushed it through, and the administrative director. So it was a big change in leadership, and we didn't have that going in. I mean, there were it was, you know, it will be an interesting case management study of a failure of a system. That said, I think a lot of the work that went into designing is being used for new e-filing solutions, for new case management, that kind of thing. But it's a hard, you know, we're a big state to come out with any kind of big system. And, you know, for those of us who worked on it hard and really thought it had really cool features, and a lot of the stuff would have just, you know, you could, I've worked on it because it's actually in operation in some courts, and it's pretty swell. But
And then there's also e-filing, pro se e-filing versus attorney e-filing are two different universes. In Minnesota, they've had a pro se e-filing project in Hennepin County that probably will have lots of good lessons learned.
right.
How that developed.
Yeah, because that's the other thing, like in the federal court system, I'm sorry,
Which county was it?
Hennepin. It's Minneapolis. Yeah, so in the federal court system, for example, there's a mandatory requirement for e-filing, but only for attorneys, and you have to get special permission if you're a self-represented litigant to e-file. And there turns out to be a form that's like, do you know how to save documents to PDF? Do you have access to a scanner? Do you have all these things in place so you can do it? Because the reality is that I've talked to attorneys who practice in the federal system, and they say, it was kind of hard to do when I first started. But now, after 2 or 3 cases, I totally dig it. Well, the reality is we hope that most people aren't going to be getting 2 or 3 divorces in rapid succession, so they're really learning this process well. You know, it's like, this is your first time. And you know, people say, oh, well, everybody knows how to use an ATM. Well, I humbly submit there are very few processes, that in legal processes, that are quite as simple as using an ATM, right? You know, and even, because I'm so old, I remember, you know, the first few times I used an ATM, it was a little bit complicated. And so it's just, you have to decide, you have to be mindful of the regular filers versus the uncommon filers. And in any kind of document assembly system, it is really a challenge. And you don't, on one hand, if you design it so step by step, people who do it every day are like, slash my wrist, I just can't handle it being so slow. So, you know, sort of thinking about how do you, you know, potentially have 2 levels of design or 3 levels, whatever, but that you have to be mindful of that. So we've been talking about this. I say California is really a court annexed, you know, we're building things in the court, but we have some programs in law libraries. That's certainly a model that's definitely growing, because another place people go to get information, another place, as more stuff is online and web enabled, that's another resource. And the community-based, one of the other things is, you know, you saw the state, you saw California and how spread out we are. We are always interested in community centers where you can go provide information at a place that's actually convenient for folks. And if we send people out personally, then there's also sort of that connection. Immigrant communities are often not as comfortable going to court because they don't know what's going to happen and whether ICE is going to be there and what's going to happen. And if they establish a sort of personal relationship, they're much more likely to feel comfortable about coming to court. We are also very interested in, as we have technological solutions, training those community-based organizations on how to get people using this. How do you help people do a restraining order online that can then be reviewed somewhere else? Or how do you do those kinds of things so people can do the work at a place they're comfortable with that has people who speak their language and understand their culture, and then we can review it here and then here. Yeah.
Have you any statistics on access, just internet access among some of the people who are the primary customer? Is this everybody in California? We have 38 million people, all of whom actually have ready access. Is there some percentage of them?
I don't have those off the top. I mean, the Pew Research Center does a ton of research on internet usage. What we know is that there's a growing usage of mobile devices among, I'd say, the low, certain Hispanics and African Americans tend to use mobile actually more than whites. And so that's one thing that we need. And again, you know, there are some legal procedures that are, I think, kind of complicated to do on an iPhone. But we need to be, but that said, you can get people to access to information, but we have to think about that because more and more people, it's going to be mobile. That's absolutely where we're going. My theory with our design has always been, I don't need to serve everybody through technology. That's, you know, I'm not trying to do that. I'm trying to say if I can pick off 10 or 20% of the people who would be coming to a court and help them online, then that gives me that much more time for those people who need in-person assistance. And I know that over time that percentage is only going to increase because more and more people are going to be comfortable using technological tools. But that's always been the approach because with technology you make, you know, a one-time, often a big investment, but it's a one-time investment that you then just have to maintain at a lower level. Where with in-person assistance, you need to maintain the, you know, it's a staffing cost, it's an ongoing cost. But I'm a huge believer that that we need to do both. We need to be really smart about our technology, but we're also going to need people. Because the reality is, people with legal problems often just want to talk to somebody, and they need somebody to pay attention to them and say, wow, I really hear that that's horrible, and you know what, the legal system may not be able to solve that problem, but here's what we can do for you, and how can we help? And just, frankly, for many disenfranchised people, having somebody in a position of power pay attention to them makes a huge difference.
So there's another argument here, and I'm not disagreeing. I mean, I think
Right.
what you're saying makes a lot of sense, and of course you're the person who's doing it. But there is another argument, just kind of curious your reaction to that, which is that some folks may find that entering into a legal action or doing anything with the courts is just too much work.
Mhm.
They don't know how to do it.
Right.
If there's technology, if there's a website, it makes it a lot easier to just go and click around, find a few things. Lowers that cost enormously.
Right.
You may find more use of the court system. Good use,
Right.
proper, appropriate use of the court
Absolutely.
system
Yeah.
by bringing technology into
Yeah.
the picture.
Yeah, no, I mean, in our data, we've been very conscious about not saying that self-help is going to, I mean, it does save the court a lot of money because people are coming in and they're better prepared. The courtroom time is what's most expensive in a court because you have the judge, you have the bailiff, you have the clerk, you potentially have interpreters, you have all this security. So it's cheaper to spend the money on the self-help side. On the other hand, we hope we're encouraging getting more people into court. That's the goal. It's both access and efficiency. So we're never going to say, wow, the whole goal of this is to save money. No, you may have just as much work because you have more people coming in, but hopefully it's, people who would never have access to the court system before.
And it's important to remember, these case types of family and landlord tenant and the consumer, they're not voluntary cases. I mean, you don't really have a choice. It's pushed on you, so you got to deal with it or keep your head in the sand and end up with a $50,000 arrearage in your child support case, which happens more often than not. And I think your point of when we do make this information accessible, we have a better chance of getting people not to have $50,000, $100,000 arrearages because they can educate themselves and they ignore the envelopes from the child support agency, but they'll read the court's website.
So we talked about the access to that information, and what about usability of the information, the fact that the information is there? Do you have any statistics on whether or not people are able to interact with the information, actually how they use it on a laptop or how they use it on a cell phone? Because sometimes it's important as well. And following that is the question, do you also try to evolve the system and make it update it as, for example, you discover that an information is not usable, it's not used, people don't use it because A, maybe they don't need that information, or B, because they don't have access to that, or do you keep the system flowing?
Yeah, no, I think those are really critical. We try and do all of that, and have some analytics. I mean, in the past, people on the self-help website were spending about 13 minutes, which I think is a pretty substantial amount of time on average for people. We get about 4 million individual users a year on the self-help website. So, does that, are we continually evolving? Yes, and honestly, we also have to continually monitor the law, right?
Yeah.
There is no, we're not like, oh, we're done, because the law's never going to change. But there are absolutely efforts. Could we do more? In my opinion, sure. I don't, frankly, love our design of our self-help website, but that's, we don't get to roll all of that, and we are continuing to say, well, maybe if we did would a button work better? Would this work better? And trying to do testing. But do you want to talk some about usability?
Yeah, well, I think a key thing for people that are in the middle of their legal crisis is, in the Alaska program, we would try and identify who's the person that's going to help you. That might be a relative who's pretty good at paperwork, that might be a social service provider, somebody. So we tend to get a whole group of users of our technology who are kind of institutional players, and they get used to where they find it, but they're not very sophisticated institutional players. So once you move, like the button, they're lost. So there is, sort of this value of you have to be very cautious with your community. That being said, like Utah did some great work with analytics and totally redesigned their self-help webpage based on the information they got. So that's, that's a valuable thing. Then we have programs where these self-help centers essentially act as the feedback loop to the design folks of what's working, because you're interacting with the user and you can tell, like, were they able to find it, did they get the right thing, and that not only on the technology side but also on procedural stuff inside the courthouse and with the judges. We get a lot of human feedback.
Yeah, and I think my recollection is you did a lot of redesign of your website based on the phone calls and how people were asking questions, and so then you can do a Q&A format that's actually based on real-life questions and the way people are phrasing them.
It was actually designed, we opened a helpline in Alaska first, a statewide helpline, and designed the website based on the questions that were asked. And so the logic trees were built the way that people asked the questions, not the way me as a lawyer was trying to think about it. And that, that was great for the user. I'll tell you, the court staff and lawyers went crazy for a long time. They're like, we don't think about it like this. I'm like, well, get over it. That's how we're doing it. So.
Yeah. No, it's a huge challenge. I mean, one of the things, we've done different user testing things, and I thought I was so smart. I was like, we're right across the street from the self-help center in San Francisco. Why don't you just go across the street and talk to those people? And what our web people said is, well, everybody who's there didn't think to go onto the internet, and they want to come to court and they want to get, so why are we bothering to do the self-help website? Why don't we just design this for lawyers? And I'm like, no, bad focus group, I think. 4 million people, there are probably some people out there who are actually using this thing, and we could do a good job. But anyway, I hadn't thought that through. So just, I guess to say there are a whole variety of ways to provide the service, and I think that's, that's really based on the community, yeah.
I was wondering if you could go into more detail about how they approached the questions differently and what were the different order in which issues came up.
Well, so from a legal standpoint, whether you have a custody case or an unmarried parent's case or a divorce is really important,
Yeah.
and it goes in a different way. Everybody has a custody case. Like, it doesn't matter. Like, from the layperson, if there's kids involved, it's a custody case, and so they'll go a long way down the line. That's the sort of, so the question was, do you have kids or don't have kids? That was the entryway question to then take you down. Bonnie's example of, I have a family law problem, but it turns out to be a criminal problem, right? I mean, you kind of have to watch for those things.
I'm trying to think. This is a picture of a self-help center. It's an older picture from Marin, but I mean, it's sort of an interesting model in terms of they really use technology a lot and had people with their population, had people online a lot, but just to get a handle on some of that. I'll just say the other thing that I get to share, it's sort of a secret. That's why it's on a slide, is that our vision is not just that the self-help attorneys are providing assistance to people, and I mean, they use volunteers and paralegals and all kinds of people, but that it is the person in the court who's really responsible for being the voice of low-income people. Because there are all kinds of ways that attorneys and judges can have communications about general issues, but if a self-represented litigant has a problem, by definition, it's going to be an ex parte communication because they can really only talk knowledgeably about their own case. And there are systemic problems that come up that there was never a voice in the court before to say, I don't know if you know this, but this is what's going on, or this is how clerks are treating people, or this is a common misunderstanding. And so it's really trying to provide a voice for low-income people in the courts and provide a person that legal aid and other people can go and talk to and develop coordination with and do other kinds of things. But a lot of times they're winding up being they're oftentimes in management and actually involved in making more substantive decisions about how courts can operate more effectively. Because when you look at those numbers, it seems to me that the court should be assuming people are coming in without lawyers. Not that we should design our system for lawyers, but if you have 90% of the people, you should just start shifting your framework and say, okay, great, those lawyers, they're the outliers now. Let's design our system so it works well for people without lawyers.
And our system, as it's built for lawyers, you know, the great thing about, I had this law school professor who used to say the thing she loved about being a lawyer was it was the only game where you could like change the rules as you were playing, right? I mean, that's what we're taught to do, is how to change the rules. We know when we can break the rules and we know how to break the rules. The self-represented litigant can't do that. So things that seem really simple to us, like getting a continuance, you know, they have no idea how to do that. And so when you build in that feedback loop to the judges who are like, oh, well, okay, great, let's see, we could, you know, put some other processes in place, the whole thing runs a lot more smoothly.
Yeah. So there are programs out there, and we're continuing to work on them, and I frankly think that the future is going to be what we call document assembly programs, so kind of TurboTax to fill out forms and that kind of thing. But where we started, and I think it's another thing to think about in terms of the coordination, is that we at the AOC decided that there were some vendors out there who were doing the TurboTax type things. So we really wanted to help the self-help centers be more effective. So we go through a whole series of questions, people fill them out, the information out, and we initially used Justice Core. We're finding more and more people are able to fill out basic information online. But we go through, people fill out very basic information, name, address, phone number, names of the kids, birthdays of the kids, that kind of thing, the date they got married. Most people know that. Data separation, we leave blank. Because data separation in family law can be kind of dicey. A lot of people don't say, okay, that's it, I'm out of here. There's sometimes lingering issues. That can have huge property consequences, pension consequences, spousal support, all kinds of things. And there's very interesting case law if you want to read about it. You know, don't continue to take your laundry to your ex's home, because that may be considered maintaining a relationship. But for most people, it isn't a big problem, but for a pretty substantial portion of the population, it can be a big issue. And attorneys freak out on this one. This is where they kind of go, oh my God, you could never do this stuff, you know, without having a lawyer and a lot of information. The reality is, if you have somebody who's filling it out in TurboTax, they don't want to read about data separation and why it would be, you know, it's like, oh my God, you know, don't give me more legal stuff, I'm just moving on, you know, I'll choose a date, this is the date I think I'm moving on. So what we've done is, instead of that, then they come in, they fill out that basic information, they get all the forms in order, it prints out, and then in the workshop, what they do is talk about data separation. Talk about what community property is and how you might divide it, what are ways people handle that, how do you handle division of, you know, working out custody arrangements, that kind of thing. So we're trying to use computers for what they're good at. The name, address, phone number, all that stuff that gets printed on every pleading, everybody can read it, it's understandable. You don't have a clerk saying, oh, I'm really sorry you can't get your divorce because on your first piece of paper you said your name was Jonathan T. Smith, and here you're just saying John Smith, and oh, you have to reserve everything, you know, which happens. There's that kind of consistency. You deal with those kinds of issues. But you're really allowing that kind of personal contact, but you're not using your attorney's time to say, okay, now everybody write your name here, you know, now do this. And so I think, honestly, I think that's where I'm hoping that we will be able to really provide more and more assistance. Again, trying to be strategic, not saying every technology is the solution for all of this, but from an e-filing standpoint, everything that you really need to have e-filed is typed into the system. And the other stuff, you know, is nice, that can be PDF'd, whatever, but the court doesn't need to have it in its case management system, but it's an interesting model. So, want to talk about best practices? Yes, please.
Yes, so this was in your reading. Everybody did all the reading, right?
She did.
So I think this probably all comes very naturally to all of you. I mean, but the obvious, we need clear, simple, and up-to-date web content. That's already been brought up in the questions. Keeping that up to date. We had a fascinating session at a conference we had a week ago where people in this sector all come together. And our session was on managing multilingual forms and resources. So we basically, in the court environment, don't have any document management systems. We don't have any mechanism to track terms. We do this, we create every document on its own, it stands by itself. So, you know, we basically spent this workshop kind of fleshing out how complex this is. If you make one of the speakers gave this example, a judge had made just a couple of very minor changes on a landlord-tenant form, and she had 2 pages of places that she had to go, and other forms had to change, and she had to do it in 3 languages because they maintained a trilingual website. Posters, how you distribute information. It's very complicated. So just the clear, simple, up to date is, we have that in, we throw it in, but that's a much more complicated.
They had to retape audio.
Yeah, right.
Right, redesign their web materials,
Because
redesign all the training materials.
The document assembly materials where, they had put audio files in, they had to go then find the person who had done the original recording to re-record. The opportunity, I think, for people interested in technology is that we don't have document management systems in the court system. All of this is literally living on the individual's computer or their little folder on the drive. I mean, they didn't even have really a well-organized shared drive. They were dealing with an older, the system for their webpage did not have, wasn't really a modern content management system, so they couldn't keep track of anything. And we had somebody talk about how, at least in Drupal, when you did it in Drupal, then they kind of got a message when a certain part of the English website was changed, and they would know to go to the Spanish or the Chinese website. But if you don't have that, and a lot of systems don't have that, you literally, there is somebody with a list at their desk who is trying to track this. She ended up having to pull somebody out of retirement who had set up the original system. And this was all to deal with like 3 changes on one form. So lots of opportunity there for people interested in technology. Forms, we're going to talk later about accessible forms and plain language, which is really the critical thing to think about with forms, but they are the cornerstone of self-help. If we have to, it goes back to that legal information, legal advice distinction. If we have to write up a form for the person who comes in, or write up a pleading, right, that's legal advice. I'm doing a customized piece of service for you. Once I have a form, I've neutralized it, and the court can use it. Completion of forms online, we have a lot of document assembly programs that have developed in recent years and are getting more and more popular across the country. I don't know if you want to talk about specifically some California examples with.
I'll pick that up later.
Okay. And then we've touched on the case management and e-filing, and from our previous conversation, we've heard how we're at the infancy of, and this is true nationally. I mean, there's California. The example of California is the one of the, if not, we'll just go the most advanced state in the country. So most other states are really struggling. The forms issue, just to kind of give you an example of how bad it can get on the other side of things. In Ohio, where judges are elected, in the same courthouse, you can go from courtroom to courtroom to courtroom and be required to use a different form for each courtroom.
For the same
matter, because the judge is controlling that. So, I mean, across the nation, we have a huge range. Whether forms are mandatory or optional makes a big impact on a jurisdiction, whether you can use things. In Alaska, when I started the Self-Help Center up there, Alaska is much of the population lives in very remote circumstances, and so we have very liberal kind of down to basics rules on due process and so forth. So often people, like if they got served with papers and they didn't like it, literally, like, here we go, no, hand it to the clerk. So the clerk would tape it down and send it back to the judge, and the judge would accept it as a non-conforming answer. Now, in most jurisdictions, you would not get that kind of treatment, but because of Alaska's situation, at least people got access to the courts. But so when I created the forms, my first greatest accomplishment from the eyes of the judges was I got on everybody on 8.5 by 11 pieces of paper. Like, that was good, because now we could punch holes in the top of it and put it in the file. So, forms, when we look at this as a national issue, this might seem like a simple list, but this is much more complicated, and when you get down to, some e-filing, you can imagine, if we're going from corners of papers to e-filing, the expanse is wide.
So just a quick clarification, so the Berkman Center report is in the readings, but in the readings for next week.
Oh,
Actually, we have
sorry.
we have Phil Malone, who's actually one of the authors of
Oh,
the
okay,
report. He's
he's
coming
good.
in next week. We'll be
Excellent.
addressing that too. But that's a great preview. That's great.
Good report.
It's, yeah, no, this is an excellent document and really kind of gives you the whole territory.
And also, we typically take a short 5 minutes break,
Okay.
about so the halfway point of
Sounds
the
good.
class. So
Okay.
if
Yeah,
now
this
you
is
think
good.
would
This
be
is
an
actually a good
Yeah,
place.
good
yeah,
sec-
that is-
Okay, great. So let's
Yeah.
take a 5 minutes
minutes?
break.
Yeah,
Then.
and then we'll figure
Let's
out.
reunite it.
Okay. Okay.
3:13.
Okay.
How you doing?
So maybe we don't have to-
I think I'll go with the.
Oh, yeah.
We'll talk on Monday.
I
I
have
may have double booked myself. So let me ask Monday.
I would like for you that if we hear or instead of names or something like that, there's so many different ways that you think about presenting. I don't want to just give you like, here's the text, guess, and here's the not guess. This program can automatically calculate for each case how often you should write. But I think what I'm saying is your cases that are random.
Yeah, no, I mean, from 10:30
Like that.
I would have.
We like that.
Unfortunately, you got it right.
Well,
Then you can just
Yeah.
distribute that however you want. And then I think maybe this weekend, as I try to finish this up, maybe you can start outlining like the word moving parts of the paper. So we can start thinking up.
I think I'm.
Start thinking about like background, your research.
Oh, no.
Hard first, alright, this will just start
We'll do then Monday.
Okay. There's like first blocks. So next time, like, because I'm working, I write it. So, this should be done by the end of the weekend. This is definitely the hardest part.
Water, or water is, yeah, Diet Coke.
I still have to get
Sure.
Yeah.
No small task, so. No matter.
Yeah, a lot of this is pretty cool. It's actually, so in the end, I mean, you could run this for every single thing in the entire US.
So we won't really spend a lot of time on that, but we'll just do that, and then you could show just a couple of examples.
Yeah, I think that's useful.
Yeah, that would work. So the way that the program will work, so this is step 1 of the program. So right, obviously all you have to do here is just print this. Step 1. Step 2 is just, I'm going to work with videos. I'm going to do instead of things like no, our taxes, and then your qualify whatever. Check it in the recorder.
Yeah. Sounds good.
Because the way they do citations and well, they do it in case text and actually do it in parsing. Is that you get a page number exactly. You would look up like Q US 13. Boom, found it, found the page, full tag, and then you just get tagged.
Yeah.
So yeah, I mean, if I've only run this a couple times.
Gets to.
I'm just like the cases 16 lines, so I started thinking of just like, right, here's three cases. I run around with this, but you just
My
run it
undergraduate was
over
in
and
Boston.
over.
And,
I'm making something
so,
like a way to write it
so
myself.
I don't know.
Yeah, what they want any problems, register.
1,000 or something.
Which
Which seems a lot.
You get to keep it for your life, and maybe one day you're gonna get it.
Right, right.
You know, I feel like it's.
So I might try to
Everybody
figure
else
out like some way to
resells
iterate
them.
through all the last cases decided.
Yeah, well, that's what I was gonna say, so I graduated in the eighties, and I went to Northwestern, and this just, boom, that's exactly.
I mean, it's not hard to do, it's just a matter of time, it's just using power. You just saw it run.
Here's the second.
Case studies.
Yeah, no, everything's great, actually. It's gonna be
Yeah, so it's
Yeah, so very
I
different
think
sort of
guesses
different
are, I
lenses.
don't know how good that is.
Right
It's a discussion we can have.
now, there's
The thing to really take away, the reason I showed you Erie actually is because you see those London tags. That's very unique. Most of the time when you do this, you get positives and you get some else. The other executive rationale is a lot of tax incentives. So I'm not sure.
So you know what's gonna happen, even though
Because it ultimately, right?
So as opposed to like here, this is useful for when you have to get things that's exciting. I might be nervous about that also. Theory about federal commerce, so carry through usage the check on that is like in
Yeah, so maybe what you should do is have weekly meetings, so that means 2 more, and then maybe once a month. And then just see more people,
more likely to carry. Yeah, so we're
I could actually see how that would be a more accurate.
I like that.
Yeah, let's talk about that too.
This one has a lot.
Thank you. So, I don't know why it's showing up in my
A lot. Sure, it's
I have no idea.
not helpful to range the
Oh.
Then you start, then it's just
Which I meant, but it's like, go back. Right. Going to the president gave me going back to the conference a bit. And at one point I sat next to him and I'm like, really worth it my paper now? When he's
Somebody else
the market regulated whether it's like in a way that every judge can make a decision they can use or lawyers can decide about themselves. That comes up a lot, especially people forgot me in those marketers about me in the state. You're right. Because you have one system is to go and equal judges don't say just be like the president like this court and say something else. Or everybody. Good luck getting that problem solved. This is a problem. And in fact, this is why I think kind of scared. some problems, sometimes the sensitive stuff, the problems of the lawsuit. Just because of this, so battery is very hard to understand if you're not studying for legal procedures. So rest around here.
Nee, maar dat misschien heeft het wat te maken met setting hier of zo. Ja, wel, maar het is leuk als de kinderen gewoon een bos hutten bouwen zijn. Ja, het is echt heel lekker. Ja, leuk.
Right. Okay, so we've gotten rid of some slides and we're going to try and move quickly through some others to hopefully make our time. But I did want to, we've talked about some of this, but I wanted to touch briefly about remote challenges because they're near and dear to my heart since I spent 20 years in Alaska. And I think the relevance for you all where you are in your careers and the future of your career is while things like internet, so in Alaska's big, let's start out with that. If you superimpose it on the lower 48, it goes from one side to the other. Okay, so it's really, really big. I mean, big beyond your counties or Texas is, nothing. So we went in 2001 with all a phone and internet-based system, and to get to your question of internet usage, I mean, Alaska is a little bit unusual because the internet was so vital to getting any information from the outside. But we were able in 2001, when I was interviewing people for the job, the non-attorney staff, one of my questions was, have you ever used a mouse? And not everybody could answer that question. However, we were able to launch a really successful web-based program. Part of the reason, and I'm just going to kind of comment on these environmental things because you should watch for them in your life. I attribute it to two things. The first was Senator Ted Stevens, who was a longtime senator of Alaska, really saw the power of what the internet could bring to remote areas. And so he built this amazing infrastructure for our state. And in all the public schools, people could get internet access. So in a village of a few hundred people, you could get high-speed internet access when you got to the hub community with the school. So that was, getting that infrastructure of people having access to high-speed internet is, I think, going to be one of the biggest challenges to spreading tech solutions. The second is having a motivation for people to learn how to use technology. We piggybacked on Alaska Airlines. Everybody who lives in a remote village in Alaska wants to get out in the middle of the winter when you have 3 hours of sunlight. And where do you go when you're from Alaska? You go to Hawaii. And to get to Hawaii, you have to get on Alaska Airlines. And Alaska Airlines had built this amazing website that our users who maybe hadn't completed, 5th, 6th grade were great internet navigators because they were it was a good website and they were really good at navigating. So we were able to build on that, and when we pushed out a court website to them, they were like, all right, we're ready to go. and they knew how to navigate. Now the big thing that's changing, that's changed today is, right, everything, we were dealing with landing pages and we could control how they, went down on the architecture, can't do that anymore. Search engine optimization, gone, right? Everybody just search word and then they're in. So that's a big problem I think that courts are facing in terms of how they've laid out information, and we don't really have any answers. But anyhow, I throw that all out there. Ultimately we could put all, this great website that everybody can navigate, but we needed the human element, and which is why we connected the phone line to it. So we're dealing with people in Alaska that are in remote villages, limited education. They're these people. Yet once we started helping them, they were successfully navigating through their court cases and being able to access court with no problem. How did we do that? It was the human element of just being able to, figure out what they were stuck on. Weird things you can't predict, and you also then have to kind of fold in cultural issues. So in one particular region of Alaska, the indigenous population that lives there, you don't challenge authority directly, or you don't kind of bug people about stuff. Well, and you don't speak up. So I had, we developed this little mantra that we would tell people, I can't tell you how your court case is going to come out, but I can tell you without a doubt, our system is based on being heard. So if you don't speak, you're not heard. If you're not heard, you lose. I can tell you, you will lose. And that kind of, you've got to speak. No, the judge is not going to be mad at you for filing a motion. People actually think judges are mad because they are being bothered. So that kind of human interaction is really key, as well as, in terms of helping people understand the system, as well as just, where do I put my name on the form. So in that, you're distinguishing the education of educating them about a process versus concrete assistance. So when I talk about educating about a process, most individuals are going to come into contact with legal process concepts a number of times in their life. When I talk about that, it's the idea that you have a motion and opposition, due process, that both sides you get notice and you get an opportunity to respond. The people don't naturally assume that's going to happen. I mean, like 5-year-olds get it, but somehow by the time we're adults, we've lost the fact that both sides get to speak. So I think when you look at the kinds of online education and the long investment that you might make in improving people's ability to access the justice system, getting just education out through technology is valuable, and especially in rural locations. And so Alaska and Utah are two examples that have centralized their locations. One place they cover the entire state. And then we also we have video conferencing, not in those states though. California is.
Yeah, we had some pilot projects, and again, we have staff, but we have one attorney in one county who would move around different days, but she would offer pretty much everything either by workshops or by through video conferencing. So we'd have 4 different centers. There was a staff person who was a court clerk who would get everybody set up with the papers they needed, and just making sure the equipment worked, all that kind of stuff. The attorney would be either a staff attorney or pro bono or other people depending on the case, would come in, offer the workshop in one location, and then in the other locations they could raise their hand or ask questions or whatever. It was very interactive. And part of the role of that staff person in the other center was also to be looking and sort of saying, you sure you're getting this? And to be monitoring, because a lot of times people can't read or write, and so you don't they're not sharing that information with you, and you were only picking it up as the thing goes along. So to provide that kind of assistance, and then the clerk can do all kinds of, like, you need this many copies, and this is where you go, and all that kind of stuff. But people are getting that legal assistance through the workshop. She also left the monitors on all day, and so she would just sort of watch and see what was happening. And if somebody was having a 40-minute conversation, she might kind of go, hey, so how's it going? Is there anything I can do to help? Because it may, there was sort of supervision, and is this just getting way beyond what a self-help center might be reasonably doing, or any kind of assistance? Can I answer a question that would take care of this? So it was really interesting. The evaluation people were really, really dug it because they thought it was new and trendy, and they felt like they were getting interesting technology. So sorry for the text is difficult, but that's the attorney talking to the people in the other centers, and a very, very successful model. What we found in evaluations, we did a whole series of model pilot projects and did some evaluations. So some really key things. The self-help centers were much more effective if they were actually in the courthouse. That's where people went. They didn't lose their papers. We saw about twice as many people if they were in the courthouses versus even being, short, not very far away, which we didn't necessarily anticipate. The coordination of that self-help center staff and attorney with court administration judges was really critical. Giving people materials, here is your instruction pamphlet, go read it and do it, was not generally enough for most people. They really needed more assistance. Computer kiosks, where, which was, and people still refer to them, you go and you answer the stuff kind of like an ATM machine, just don't seem to work unless they're staffed. And the basic thing you can, and now it's so much easier just to buy a computer, why do all the stuff for a kiosk? What we have found is that people don't need necessarily a lot of time, but maybe 5 minutes of, so tell me about your issue, here's the thing, here's how we can help you. You can sit down at a computer and this will go through the questions and let's get you started. And if you have any problems, I'm here. But then people are okay, they'll calm down. What they don't want is to drive to the courthouse, pay for parking, stand in line, whatever, and then be told that they have to use a computer. That just doesn't work for people. But I just saw a self-help center in the Bronx, and they claim they have the lowest education level in the country. And they've got a ton of people using the computer, and the person they have helping them is the court security guy, who's just kind of like, hey, yeah, let me get you started. I mean, this is not a lawyer, right? But all kinds of people are able to modify their child support using these computer programs. So but what we thought, there was this whole vision, oh, we'll just put a kiosk at the mall, right? And I think about it and I think, why would we think that people want to start filling out forms about divorce at the mall? It seemed like a great idea at the time, but and then again, giving somebody the opportunity to talk to somebody is key. The other reality is, I don't know if you've ever had to use, well, obviously you do, other people's computers. They're always set up wrong. The house is always wrong, and I've used a lot of these systems that are anticipated to be really simple, and I always crash them, and I don't need to. But they're set up, they're not intuitive for me. And so, it's just sort of, again, getting me calmed down, being able to say, I can raise my hand and go, I think I messed up somewhere. Then people are okay, but you need to have that human element.
Just in terms of location, I'm wondering what your thoughts are on university-based self-help centers, because there's quite a few. Stanford has some, my university has some, so I don't know if you've had any experience with those.
We haven't, and I think it's really possible. I think the reality is people go, if you can get people to come in, I think it's great. And obviously there are other case types, there are other kinds of things where it makes a huge amount of sense. So I'm up for all of it. From a court perspective, if you're doing kind of mass volume, I think you need, I think you need to have the court-based program, and then you have adjunct kinds of things that help feed in. That's because the reality is I used to practice across the street from the courthouse, and the number of times the clerk would call and say, Bonnie, you've forgotten this piece of paper, and I go, no, actually I didn't. But, just walking across the street, things get lost, people forget. We have to develop much more systems. I think about it, if I go to a doctor and then go to the pharmacy, if I didn't have a prescription pad, I'd probably be going, he said something about oxycontin, something. Actually, I have a cold, and this is, let me go through my symptoms, right? Because I don't necessarily have the technical language, and it will have been lost from here to there. So we need to be developing all kinds of systems to be able to convey that information and do it. But a couple of other things that people are doing that I think we're doing a lot more WebEx. Let's go through the forms on a one-on-one WebEx. So we had one attorney who was in Chico, who was supervising a center in Yosemite. And the clerks would do the kind of, here we're doing the stuff, but she would answer all the questions, go through the forms on WebEx. We have another, San Diego, a number of programs you can set up an appointment online at the court for workshops. Probably should be able to do it for court hearings, but anyway, for now you can do it for workshops. And they give you a sample declaration. And if you fill out the declaration, basically your workshop is about 10 minutes of explaining this is how you process it. If you don't, okay, the workshop is about, but we're trying to get the basic information so everybody has enough to come in. And then I think the other big thing I'm excited about is any kind of connection with 211, to be able to connect people to the other resources. The reality is with housing, a lot of times people are going to be homeless. So is there a way we can connect them with the other resources they're going to need way beyond their legal problem, and how much of that can be done online? Just to give you an idea, I think I talked about savings for the court. We did a little cost-benefit study a few years ago, and we had this program in San Joaquin County that was self-help providing guardianship assistance. And they had 7 continuances a year, which meant there were problems that needed to be dealt with and people had to come back. There was a funding challenge. They had to drop the program. They went to 402 continuances the next year. And the judge said, you will keep track of data because we will get this program back, because I am not going to have 402 wasted court appearances, basically. Because what does that mean? Not only does the litigant have to come into court in a guardianship case where they're like willing to take care of a kid so that the kid isn't in a dangerous situation, but the clerk has to pull the file, they have to read the file, they have to go through all this stuff that costs a lot of money. So then we were able to monitor what the impact was. So they went to 366, and then when they started providing workshops, they could get it down to 98. And so it's sort of like, what is the right level? But we looked at this in a number of other number of other models. And in general, when we offered workshops, it eliminated 2 continuances per case, sort of across the board. That was the other thing. We talked to the clerks and said, so when this wasn't working, did you get a lot of questions? Oh yeah. They estimated they spent 45 minutes per litigant just answering questions, and they weren't able to do anything that they felt was helpful for the person, but they got a lot of questions. So our sense, looking at this and some of their examples, that for every 13 cents of investment in self-help, there's $1 saved, which is remarkable. And then we did start looking at, aren't there costs to the litigant in terms of taking off work, daycare, other kinds of things, and ask people what they were spending. So there's, again, it depends on the case type, how are things going, but it's a really valuable kind of service for folks, and that has been very helpful with court systems to maintain the funding, even though there's been huge drops in court funding, and the legislature has also liked it as an efficiency. So we talked about forms. The only thing I wanted to also say is, when, as a practitioner, when you have forms, you get really used to looking at them and knowing where to find things, and it's a huge time saver. I've been in a situation recently where I actually had to, God forbid, read pleadings and went, how do judges do this? Because I'm used to knowing exactly where to look, what the elements are, and if you actually have to read it, you're going, did they say, did they meet this challenge? Did they do this? It's a huge hassle. So forms are big. So.
Yeah, and I just want to talk a little bit about literacy. You can Google this National Assessment of Adult Literacy, and I encourage you, if any of you are going to work with the public, design anything for public consumption, get really familiar with the work of these people. And what they look at is they have 3 different kinds of literacy. They evaluate prose literacy, document literacy, and quantitative literacy. And when we talk about literacy, generally people usually think, well, it means can you read? And people can read the words on a page. That has nothing to do with whether they can organize information, analyze information, problem solve, which are all the things that actually feed into our literacy. In a nutshell, the really kind of chilling takeaway from these folks is they look at the population, and I'm really summarizing very quickly in the interest of time. Take the population and divide it into fifths. So you have like different, literacy level 1, 2, 3, 4, 5. And the bottom 20% of the population falls into level 1. The skill set that you max out on to get into level 1 would be finding the number on a social security card. Okay, so that's That gets you, 20% of the population is living there. That is the most talented thing that they can do. When we look at really tangible literacy, that would be the ability to like scan this document literacy. So we get to level 5, the most literate people in the country. The skill set you need to get into level 5 is be able to fill out a 1040 easy tax return. The skills they're looking at there is that you could read your W-2, you could find the numbers, you could accurately transfer them to the 1040, and you could do the basic computation, the 1040 easy. No schedules, no nothing. Okay, so the child support affidavit that everybody has to fill out in court requires more skills than a 1040 easy, because you have to have multiple documents and you have to be kind of comparing and contrasting things, and you have to. So we are asking people to operate, really in a place that they can't operate. So as we build systems, we have to be really mindful of this. And obviously, you can't build everything to the lowest level, lowest common denominator on this. But we have to be mindful that we don't forget that a lot of people are operating here, and to the extent that we can use plain language, we can minimize distractors on the page. There's a whole lot of stuff that you can do. It really is a must. And I think there's increasing research being done in terms of the way people interact with the internet, with web pages. But the problem is when you have the low, moderate income population all going to mobile, the visual distractors, right? They're very few, right? Because on the mobile app, it's just a few little buttons, and they're not having to sort through or categorize a lot of information. So their skills just get worse and worse and worse of managing a complex problem. The legal system is complex. These people just don't come to the table with the skill set. So I just, not to depress everybody, but be really mindful. And then, but California has done a lot of work on plain English forms.
Yeah, I was just wondering, you said you have 4 million users of the self-help center.
Mm-hmm.
It's almost 10% of the population in California. Do you have any kind of sense of the demographics and the population? And
no, there was a very conscious decision not to do cookies or anything like that. We have very little information. I mean, we also presume that a lot of people are coming in from other locations because people do travel through California and have different kinds of things. We also come up pretty high in search engines, so we know there are also people who, for example, we're using it in Alaska and coming in with California forms. But no, I don't have much of a sense. We try very hard to write at a 4th grade reading level because that is technically the average American reading level. But it is, it's very hard to know who's coming in pros and cons, and I'm sorry, but. So we went through a whole thing in California of, we got some money to do translation of our domestic violence forms, and our translator said, it'd be really helpful if they were in English before we tried to translate them into other languages. Good advice. So we worked a lot, not only with language, but with formatting. So this is one of our proof of service kinds of forms, and I think that there's, it's a lot easier to read than a whole lot of text on a page. And again, what it allows is for instruction sheets that help explain some of the process. And then it allows for translations. And this is a translation into Vietnamese that then refers back to the English form, because people are still going to have to, the English form is the only one that the courts can accept. Everything else is just instructional. But you can tie things together in a much better way. This is our old format. We're all excited because you can actually fill them out and save them, but yay! Adobe, that's a big innovation. But this isn't, you look at it, it's not quite as friendly or whatever, and I can tell you some of our forms are pretty darn challenging. But it's a continuing kind of challenge. So let's talk a little bit about some of the big concepts that people are working on, and one is triage. Oh, I started with triage. Okay. So triage is really trying to sort out what's the best solution for people, and where can people go? And I think it's absolutely the critical issue. I'm just very It's where artificial intelligence is absolutely going. I have some real beliefs about the importance of being transparent, because I think it's very easy to make small mistakes that have big consequences. And kind of like, I'm rushing through this form, I don't want to deal with it, I say, pension, whatever. And you know, and I don't want to like lose my pension rights as a result of not answering the question right. So, I mean, there's that, I'd say just as sort of a basic kind of thing. There's a whole emphasis though on how is it that we ask people questions to try to figure out what their legal issue is and then get them to useful resources. I was talking to a self-represented litigant the other night and showing him the triage thing, and he said, oh, this is great, I love answering a lot of questions that tell me I need to get a lawyer. Guess what, I knew that. Going in, don't, you know, get me some information, get me something that makes it worthwhile to do this, but, okay.
Yeah, and so as the sort of issue of triage grows in our community, it's not right now the kind of robust, you come in, we're going to evaluate your problem, your conflict level, what would be the different dispute options you have. We're not there. Where we are, and if you're interested in kind of seeing what's in the field right now, LSC stands for Legal Services Corporation funded TIG projects, Technology Initiative Grant projects, and if you go to lsc.gov, they give all their past grants and describe them, and they've been funding now since 2000 technology grants that have really revolutionized and made possible, you know, for the legal services community to have web pages and to be doing some really cool stuff. And frankly, when we look at national court trends, the TIG folks are far more creative than the courts. You know, this is really where the action is in our world. But they're developing triage systems that are basically to manage the legal services intake problem, right? I mean, all these people are calling, and basically you just have to get really efficient at saying no, so that the only person getting through is the person you can provide services to. And then they just, you know, they figure out how to weed them out, but they're not picking them up, and then what do we do with those folks from there? So I think that's the challenge that we're going to be seeing in coming years, and it's probably courts and legal aid kind of coming together and having to figure out how to have that dialogue together, which has huge kind of practical and political challenges, because they have, you know, legal services is representing clients, individuals. Courts are serving everybody.
So yeah, I have a question based on the triage. Do you think in the future we'll be at a place where if I can't be served by an organization, I'll be put somewhere where another organization can pick up and say, actually, we can serve you, like that's our area. Do you see that?
We would hope.
Yeah, that is absolutely the hope.
Yeah, that is the hope.
And
how that happens, and I mean, there's a couple of things. One, I mean, we can, so we have to build the databases and the referral and all that. But then there's this really practical human element. Can you wait until those people serve you, or was your court date today? You know, so there's always going to be that struggle with it.
And honestly, I don't think it's as much a technology challenge as I funded a project a while ago because we had 4 self-help centers in the LA court doing family law, and they would not refer, they all had different instructions for the same divorce process. I'm like, it can't be that different, you know, and B, they wouldn't refer to each other, and I'd say, how about putting a sign up on the days you're closed, right? You could go down the hall to this, well, we don't know if they do it right, you know, and we want to be able to, and, you know, our intake procedure is sort of different because we're getting these different grants, and I'm like, really, you couldn't just share your processes? So I actually funded somebody to make people talk together, and it's one of our big innovations.
But that is our biggest challenge, is getting people to talk to each other, to share information, be willing to share their protocols. I mean, it is usually a top secret piece of information to understand how a legal services organization, you know, local office accepts or declines cases. And it's not really, but I mean, that's how it kind of comes out. The keeping track of referral resources is just enormous. I mean, you're dealing with all these nonprofits that are so stretched for resources, and they're just putting out fires all day with people that have really serious things going on. So, you know, like, kind of one of the mind-blowing examples for me when I was in Alaska, the children's services folks couldn't keep track of the list of parenting classes in their communities. Like, you're kind of, these are the people, like, taking children away from their parents, and you don't get your kids back until you've been to your parent education. And they were so overwhelmed with dealing with their emergencies, they couldn't keep track of the parent ed classes. So these parents, they were just like, well, I don't know, go figure it out. So at the self-help center, I'm like, okay, I can do this. I can make a list, and I can put it up on the web, and basically created the manual for the protective services folks. But we have those kinds of big system challenges. Orange County, do you want to, because I think this is the only this is the only thing we have going right now in the United States that does some kind of evaluation by technology of your kind of your fight index.
Right. So Orange County, California is, this is a small claims application right now, and they're looking to build it for other things. But basically it asks, it's sort of like, yeah, do you want to fight? Do you think you can maybe work it out? Sort of what are your possibilities of collection, that kind of thing. And depending on how you answer, it may say, it'll suggest mediation. It'll say, here's how you fill out the forms, and takes you, it's really trying to also get you to the specific information you need for your situation. And here are the mediation programs in Orange County that deal with this kind of stuff. And it's really, I think, a very thoughtful, interesting model to try to help people sort out what they want to do. And small claims is certainly an area where mediation may well be the best solution to that kind of problem. So it's absolutely an attempt to try to figure that out. I'll say, when we've gone out to counties, and the other reality is part of it depends on what the resources are, right? If you go to San Francisco, they'll say, well, there are all these agencies, so if somebody comes in, they're kind of not getting it, I'm going to refer them to another agency. If I go to Fresno, they say, there aren't any other agencies, I'm it. I need to just keep, trying to figure out how to get this person to understand things. So there is that reality of part of it. Triage is very complicated because it really depends on what the resources. My humble opinion, it depends on who the judge is. There's some judges I'd send anybody in. Others, not so much. Who's the opposing counsel? Are they a shark? Are they somebody who's going to be pretty reasonable trying to get things done? It's very hard to know. Besides the personal factors, this could be a very smart person who does their taxes all the time. They've just lost their husband, and they're kind of going, "Oh my God, probate is just overwhelming." It's possible, but it's a very challenging set of factors, and one where things are interrelated, and we don't know which factors yet are more important than others. We have hypotheses, and we have different experiments that are going on to sort of test some of those. But it's going to be an really interesting challenge. I have a question. Okay.
And so we're trying to sort through this also just on the kind of by program design on the human level of interviewing people, going through how do we do our intakes, what data points are we really paying attention to. We have a project that's about to kick off where the Self-Represented Litigation Network in conjunction with the National Center for State Courts will be designing, figuring out what the business requirements are to have a triage portal. So there's going to be a lot of thinking in the next 12 to 24 months on triage and how we can take it to the next step. And this is part of the reading. If you're interested in this topic, I think these articles, they're the oldest articles that were in the list, but I think they actually hold most promise for getting us moving forward. Yeah. And we have our time. We have 10 minutes. Okay. Okay. So this is we were supposed to talk about limitations. There we go. Okay. So why don't you start talking about the different stakeholders? Yeah. So our big, the big tension here is obviously, rules versus discretion, right? We can build rule systems easily, but ultimately we have a legal system that has built into it a judge making discretionary decisions, and how do we manage that? So the first being the different stakeholder obligations. Courts, we've talked about it, they have to be open to everybody. You don't get to pick and choose who you see. Legal services and private attorneys, they pick and choose who their clients are. They have, different ways, but those are really different positions to come at the problem. So just in the interest of time. Whether technology kind of intrudes or constrains the law. So once we set up a system, you had an example last night when we were talking about this in California that it kind of started cutting off legal options because of the way it had been designed.
Right. We have there's a program in one of our counties that helps do restraining orders after hearing domestic violence cases. And it has a whole series of things that the judge can order, but there are a lot of other things the judge can order that never got built into the system. And when a judge tries to do that, it's kind of like, oops, sorry, no, you can't do that. So the computer is making law, and probably not a great solution, and I'm sure they designed it because they didn't want judges to do wild and crazy things, but it becomes really difficult. So, I mean, and I'll just say as an attorney, I mean, one of the triage points that I would do is, because I work with people setting them up to go into court on their own many times, is if they had a case where I thought they would win on the law, I would usually go in and make the appearance and argue the law, because it's not an easy thing for a person representing themselves to do. If the law was bad, but their facts were good, I'd send them in on their own. Because usually they could be very compelling and the judge wouldn't bother with understanding the law. So, I mean, it's sort of that was my internal triage, but I mean, there are so many points along the way where judges do have discretion, and the reason we have judges is because, yes, we have this law, they're supposed to follow it, but there are definitely going to be situations where the law just, particularly family law, right, where the law just sort of doesn't fit for some parameters. And I think we need to be mindful of any system that cuts off, you know, people being able to agree to different things or other ways of handling problems that aren't.
So can we tolerate technological failure? So, and the sort of healthcare rollout is a great example of it, where and you're reading one of the articles about the public welfare, public benefits platforms. You know, how much failure can we tolerate in a system? And, you know, we might decide, okay, well, 80%, 90%, that's pretty good, like good enough. But from the court's perspective, we don't give 80% access. We don't give 80% due process. We give you due process. So that's a tension as we design these that we kind of have to think about.
And I'll just say, I mean, procedural fairness, really, really, really critical concept for the courts. The reality is most of us as lawyers are really concerned about what the outcome is in terms of the legal outcome. For most litigants, the research indicates what they want is to be treated respectfully, to be heard, to feel that they had their day in court. And that's actually more important to them than the outcomes in many situations. And in many situations, I mean, they know the weaknesses of their case probably better than anybody, right? But there's a lot to be said for, again, that kind of in-person, I'm hearing you, I'm making eye contact. We've videotaped and talked to all kinds of litigants, and they talk all the time about, well, then the judge smiled, and I knew she kind of got it. Or I could tell by the look in her eyes that she understood, or whatever. Those kinds of things are just really, really critical. And I think that we will be able to do better at this with technology, but I don't think, you know, that we're ever going to be able to get rid of that human element, because people have a sense about justice and have a sense about being heard that is also really important.
And if you're interested in this concept, you can Google this, and there's a judge, Kevin Burke, B-U-R-K-E, and he's done it from Minnesota, and he's done a lot of work around this. And I mean, we regularly hear from pro se litigants, you know, I lost, but I was heard, and just how important that is, it cannot be overstated. This also goes, though, ultimately, when you think of like the contact that people, multiple contacts people have with the court system in their life, to the sort of very fabric of our society and living in a place, you know, governed by the rule of law. If you feel like you have gotten procedural fairness, you have public trust and confidence in the courts comes from this. And when I was a law clerk, I clerked in the Matanuska Valley, which unfortunately probably many of you have heard about because that's where Sarah Palin was from. And it's kind of a crazy place. And the judge I clerked for he'd just gone to the trial court bench. He'd been a federal environmental litigator. I mean, he was like in the land of, you know, who knows what people. And he would get crazy, crazy motions. And I would say to him, Judge, every time somebody files a motion, it's a victory for the rule of law. Right? They didn't go, you know, take their gun and resolve their problem. And I think we have to be mindful, like, in our involvement in this system. I mean, this kind of sounds like a very high-falutin idea, but it's true. I mean, these are people's regular contact, and this is the glue that holds the fabric of our society together. So.
Yeah. and I just also want to say, conversely, people talk about, I mean, legally they won, but they had such a horrible experience that, you know, they never want to do it again, they don't, you know, whatever.
There's a conspiracy and the whole system
Right.
is against you.
Right.
So once we, you know, when we build algorithms, I just want to go off a point, of course, then we might start losing the transparency of the system. The public trust and confidence is all built on transparency, which is a big concern of courts. So, yeah. Pension continued.
Right. We talked about, you know, how much information, we as lawyers really want to give a lot of information. Because we can think of all the different scenarios that could possibly happen, because they do, you know? I mean, I had the woman who had sex with identical twins, and that was really complicated in terms of paternity determination. And, you know, and when I'm looking at these things, I'm thinking, maybe I should ask a question. Did you have sex? Probably not, right? You know, but what would happen for that case if I hadn't asked that question? Anyway, but we just need to be really mindful about how much information anybody can take in, what they need to know at any given time. I love being a family law attorney. It was really great. And just, again, you know, as lawyers, and part of our job, honestly, is to think about all the other legal issues that we could raise that will win the case that, honestly, nobody other than a lawyer would think about. And there's a lot of value, and, you know, it's probably what we do best as lawyers. That said, again, in a family law context, may not be the most helpful thing in the world to sort of say, and have you thought about this or that or whatever. And sometimes what you want to do is deal with a problem that people have that they are presenting and help them solve it.
And then you know, I think we're in a time where we're really redefining the practice of law. All of you in the room know this a lot better than I do, because you're about to step out into it. The Law Gives, when you mentioned Law Gives, I mean, I think that's a great example of, you know, figuring out how we're going to hook up limited scope or unbundled services to the people that need advice, how much advice they need, and so on and so forth is really one of our big challenges, but big opportunities, and the time is now. I think we're really figuring out how to build that into the system.
Phil, do you have?
Just super quick, you guys mentioned at the beginning of the talk the difference between providing legal information and legal advice.
Yes.
Where, and this came up last week when we were talking about virtual law offices, where does it say that? Where is that law? Because I'm just wondering how legal startups can navigate that sort of razor's edge.
Yeah, there's actually a California court form called MC 800 for court clerks, which tries to get to that. There's a publication called May I Help You? The Difference Between Legal Information and Advice, that's also on our website. There's been a fair amount written. Is it a right line? Not always. I mean, it's sort of you can ask the who, what, when, where, or answer who, what, when, where questions, not the should I. So, which is not to say that you don't answer that question. You can reframe that question. And it's not, you know, should I file for custody of my kid? You can say, well, here are the pros and cons of filing for custody of a kid, right? And, you know, will you make that decision? No, this is your decision to make. You know your kid way better than I do, but here are things to take into consideration. So that's just as a simple way to think about it, but there is I'd say start there, but there's, who else besides John writes about this a lot? I mean, there's way more, and we've done a fair amount of work on it. The good news for the court, I mean, goes to also the UPL issue. Unauthorized practice of law. Sorry. But because all our systems are actually being developed by attorneys, so our perspective is if it's being done by attorneys, that's not the unauthorized practice of law. And from the bar perspective, the court system is the one that sets the rules regarding what is practice of law and not. So if the court system is doing it, it may be the practice of law, but it's the authorized practice of law, right? This is not unauthorized practice of law. And they will, the bar in particular is giving a lot of deference to us in terms of how far we go in terms of asking those questions. And it may honestly be different for a legal startup that's, you know, has potentially, you're dealing with more money, you're dealing with more malpractice risk, there are other kinds of things going on. But there's an awful lot that's happening in this area, and I think it will just continue to expand. And it's partly, I think, figuring out ways to give people the options to make their own decisions about what the right course of action is, rather than precluding them, setting them off on a path where you don't, you know.
And
They have more information than you do, frankly, about their own situation.
And I think for lawyers who are trying to kind of spin this cat, looking at the ethics rules and what creates an attorney-client relationship, because the question for lawyers is really, is this person my client or not my client? So that's really how you have to navigate it as an attorney. So.
Also, I mean, the last session, May 29th, is dedicated to that very question. The Mark Lauritsen will be coming in, and the Law Gives guys. They will talk about how they designed their system to navigate around those rules. Is there any final question, maybe? Mike, you have a final observation?
Kind of a field question. You're talking about self-help in many cases for these folks and interaction with the judicial side of government. Do you see any parallels or differences that you can speak to about this problem for the judicial side and other agencies of the government? Is it the same? Is it different? If it's different, why is it different?
I think that, at least in California, they're taking, the administrative agencies are adapting a lot of our material and a lot of our training. It's different in the sense there are usually not as many lawyers, and so it hasn't been seen as a big problem.
Yeah.
But I think it's exactly the same kinds of issues, and a lot of those administrative people probably deal more with administrative agencies a lot of times, welfare, unemployment, DMV. A lot of those websites were god-awful, and probably still I haven't looked at them for a while, but in terms of finding information or what the form is or anything, I absolutely think that there's a lot of things that are going on in that area, and there's a huge amount of opportunity. I do think there have been more things like, tools to help you figure out if you're eligible for welfare or other kinds of things. And again, that goes to Catherine's point. Those had better be right. I mean, let's be frank, not all humans are right in their determination, so I don't want to, but we need to be particularly mindful that we're not setting up systems that keep people out. I think that there always needs to be an appeal process. There needs to be something where you can take that information and say, I know the computer told me this, but are you sure? Did I enter an extra zero and it mess things up or whatever?
Yeah. Do you see any differences? Are they pretty much the same problem?
Between administrative agencies and the courts? I've heard ALJs, the administrative law judges, talk about this, and I mean, they just sound miserable. I mean, they sound like what trial court judges sounded like 10 years ago in states that didn't have anything. The stakes are slightly different. We usually have an appeal done to the court, but you set the factual record, the record that people appeal off of. So that's a thing.
Yeah, I don't know, but off the top, no, I don't. The people who I know in California who are working on it seem to think that there are huge numbers of lawyers. It's just as I say, they have fewer attorneys, there's fewer people, there's less pressure, and there are less people looking over your shoulder. I mean, that's one of the scary things. If you have a courtroom with a lot of self-represented litigants, the judge has a lot of flexibility in what they do, for better and worse, right? Because nobody's looking going, excuse me.
And hearing officers are often not lawyers.
Right.
So they're not as burdened by the concepts that we might be burdened by.
All right, so on that note, please join me in thanking you.